Flammurschala Fokusstrategie, Dienstag, 18. Januar 2022. United Nations, International Criminal Tribunal for the former Yugoslavia, Nations Unies, Tribunal Pénal International pour l'ex-Yougoslavie. Press Release, communiqué de presse. The Hague, 7 October 1997, Erdemović Case. Erdemović Case. The appeals chamber rules that Drazen Erdemovic should enter a new plea. The appeals chamber rules that Drazen Erdemovic should enter a new plea. The majority of the judges consider that the initial plea was not informed and that duress does not afford a complete defense to a soldier who has killed innocent human beings. On Tuesday, 7 October 1997, the appeals chamber, in brackets consisting of Judge Case presiding, Judge MacDonald, Judge Lee, Judge Stephen, and Judge Fora, close brackets, handed down its judgment on the appeal lodged by Drazen Erdemovic against the sentencing judgment rendered by Trial Chamber 1 on 29 November 1996. The judges differed on a number of the issues raised, both as to reasoning and as to result, and consequently wrote separate and dissenting opinions, of which summaries are attached to this press release. The appeals chamber's judgment. In its judgment, the appeals chamber decided the following. 1. The appeals chamber unanimously found that the appellant's plea was voluntary. The trial chamber's findings are thus upheld. 2. However, a majority of 4 judges of the appeals chamber, in brackets Judge Lee dissenting, close brackets, found that the guilty plea of the appellant was not informed and accordingly remits the case to a trial chamber other than the one which sentenced the appellant, in order that he be given an opportunity to replead. The trial chamber had considered that the accused was fully cognizant of the nature of the charge and its implications. 3. Further, a majority of 3 judges of the appeals chamber, in brackets President Case and Judge Stephen dissenting, close brackets, found that duress does not afford a complete defense to a soldier charged with a crime against humanity and or a war crime involving the killing of innocent human beings. The trial chamber, for its part, had not ruled out absolutely the complete defense based on duress. 4. A majority of 4 judges of the appeals chamber, in brackets Judge Lee dissenting, close brackets, rejected the appellant's application that his sentence be revised. 5. The appeals chamber unanimously rejected the appellant's application for acquittal. The judgment's implications. Drazen Erdemovic will have to enter a new plea before a new trial chamber, consisting of Judge Yan, Judge Karibi White, and Judge Shahabuddin. The accused was precisely informed of this decision and of the options available to him by the President after the summary of the appeals judgment had been read out. And these comments are reproduced here below, apart from the summaries of the separate and dissenting opinions. Comments addressed to Mr. Erdemovic by the presiding judge. Presiding judge. Mr. Erdemovic, you have now heard in summary the judgment of the appeals chamber. The judges have deliberated for many months in this matter because your situation raises issues of the greatest importance for law and morality. Let me assure you, however, that we have not ignored your obvious distress at the situation in which you find yourself. We have not lost sight of your counsel's strong avowal on your behalf at the close of the appellate hearings in May this year, when he said that not only do you not wish to endure a trial, but indeed that you feel psychologically unable to stand the rigors with which such a trial might entail. Let me then make it very clear to you and to your counsel that the further resolution of this matter now lies in your hands. You have a choice before you. That choice will be made from three options available to you when the matter is remitted to a trial chamber, as we have decided it should be. A new trial chamber, I should add, the composition of which has already been decided and which stands ready to hear your case with all due expedition. Your options are as follows. 1. You may change your plea of guilty to crimes against humanity for the acts you confessed to committing at Srebrenica to one of guilty to war crimes. In this case, the new trial chamber will not conduct a trial, but will simply proceed to sentence you, and it might decide to take into mitigation your claim to have acted only because of a threat to your life. 2. You may again enter a plea of guilty to crimes against humanity. Again, the new trial chamber will then simply proceed to sentence without conducting a trial, and again it might take into account the duress from which you claim to have acted as a mitigating circumstance. 3. You may enter a plea of not guilty before the new trial chamber. In this case, only will there be a trial on the evidence to determine whether or not you are guilty as charged. It may be, however, and I cannot speak for the trial chamber on this matter, that such a trial could at least be based in part on the evidence you presented before the other trial chamber, which has been recorded on audio and visual tape. In any event, which has been recorded on audio and visual. In any event, as a result of the decision of the majority of the appeals chamber, the fact that you were allegedly compelled by a threat to your life to act as a member of the firing squad will not in itself constitute a defense leading to your acquittal. However, as in all trials before this tribunal, you will be presumed innocent and only convicted and sentenced if the chamber is satisfied on the evidence presented of your guilt beyond reasonable doubt. These are your choices. They may be difficult, but they are, at least, clear. I do not ask you to take any decision now, but to consult with your counsel and weigh the matter deeply. It will be for you to plead anew before the new trial chamber. The majority of this appeals chamber has found that on the first occasion your plea of guilty was not informed. Our only concern now is that you enter an informed plea, that is, one made with an understanding by you of the nature of the charges pending against you and the consequences of your plea. We ask and expect of you and your counsel that you consider all this very carefully and that you enter an informed plea before the new trial chamber when the matter is remitted to it for its consideration. That is all. Attached are the summaries of the separate and dissenting opinions. The full text of the judgment and of the opinions are available upon request at the Press and the Information Office. Summary of the opinions of Judges MacDonald and Forha. Summary of the opinions, or of the opinion. The appellant, Drazen Erdemovic, had challenged the judgment handed down by Trial Chamber 1 on 29 November 1996, sentencing him to 10 years imprisonment after he had pleaded guilty to a charge of having committed a crime against humanity in July 1995 in the territory of the former Yugoslavia. The issues considered by the appeals chamber comprised not only those raised formally by the parties, but also issues concerning the guilty plea of the appellant and raised by the appeals chamber itself. By addressing three preliminary questions regarding the validity of the appellant's guilty plea to the parties in a scheduling order, the appeals chamber ensured that the parties were given the opportunity to make submissions in relation to these additional issues. A substantial portion of the opinion of Judge MacDonald and Fora is devoted to an examination of the validity of the appellant's guilty plea. They note that the concept of the guilty plea per se is the product of the adversarial system of the common law and justifies the existence of the guilty plea within the procedure of this tribunal. The advantages provided by the guilty plea in minimizing costs, saving court time and avoiding the inconvenience of trial to many are equally applicable to trials in an international criminal tribunal. In their interpretation of the concept of the guilty plea in the procedure of the international tribunal, Judges MacDonald and Fora propound the methodology for the proper construction of terms and concepts in the statute of the international tribunal and in the rules of procedure and evidence. The first step requires an examination of the provision of the statute and the rules themselves, and an elucidation of the words used therein according to their plain and ordinary meaning. Regard may also be had to the preparatory work of the statute and the rules. The second step involves the consideration of international law authorities which may assist in the determination of the meaning of terms used in the statute and the rules. However, no credence may be given to such international authorities if they are inconsistent with the spirit, object, and purpose of the statute and the rules. In the event that international authority is lacking or insufficient, recourse may then be had to national law where the terms used in the statute and the rules necessarily imply a reference to national law concepts, and where such national law authorities are not inconsistent with the spirit, purpose, and object of the statute and the rules. Accordingly, Judges MacDonald and Fora construe the guilty plea in the procedure of the International Tribunal primarily by reference to the statute and the rules. They then draw guidance from common law authorities to shed further light on the concept of the guilty plea and its proper procedural safeguards. Judges MacDonald and Fora set out the following 3 minimum preconditions which must be satisfied before a plea of guilty can be accepted as valid. Firstly, the guilty plea must be voluntary. It must be made an accused who is mentally fit to understand the consequences of pleading guilty and who is not affected by any threats, inducements, or promises. Secondly, the guilty plea must be informed. That is, the accused must understand the nature of the charges against him and the consequences of pleading guilty to them. Finally, the guilty plea must not be ambiguous or equivocal. It must not be accompanied by words amounting to a defense contradicting an admission of criminal responsibility. The text continues, but I will split or divide it also into 2 or even 3 parts. So the summary of the opinion of the judges MacDonald and Fora will continue in the next video.